Good evening, everyone. I am supposed to do this on my page, but I decided I'm gonna do it on my normal Facebook because a lot of people don't know about the page, so I'm just going to do it on here and try to first talk about that page because this is my own personal Facebook page, and that one is the page that I'm going to dedicate to talking about legal issues and other social issues in Gambia, basically. If you can hear me, just let me know you can hear me and if I'm clear. I don't know, am I clear? Okay, yes, we can hear you. Okay. So, I'm just looking for something real quick on my laptop. Yep, pictures. So how are you guys doing? How's everyone doing? Everybody's doing all right? I hope you guys are okay and everyone is all right. Okay, there it is. Yes, so this was what I was looking for. Yep, okay. So the ones today have not appeared yet. So basically, I'm gonna talk about two things, but then of course there's an additional something I want to talk about, and that is the bit say Sira Tambedu wants to join me. I don't even know who is Sira Tambedu. Sira Tambedu wants to join you. So I want to talk about the bit. There's this ongoing matter in the courts, and that's with Fatou Touray of Kier Fatou. There's also the lady called Tima Lawato. So they have this issue, and there are a few others, but they're not in the Gambia at the moment. So it's just Fatou Touray who's in the Gambia, and what's her name again? And Tima Lawato, I think that's the right name. So basically, what happened was these individuals are going to court. They're going to court because there has been a criminal charge that has been brought against them. And the charge, amongst other things, is basically centered on the Children's Act, where it is stated that on an ongoing proceedings before the Children's Court, and where a child is a matter a matter before the court where the court is seized of a particular matter, where of course a child is involved. You're not allowed to publicize, print, and talk about the proceedings on any media platform most especially what the Children's Act frowns against, or frowns upon more, is the mention of the child's name. The mention of the child's name, because I think it is deemed that you know, where such matters are being discussed, if it comes on the public platform, it would have some sort of impact, most likely negatively on the child, and therefore you know, the law seeks to protect the child and the identity of the child, and therefore this action of publicizing and or speaking on issues that are before the court, before the children's court, is prohibited. So, you know, you can't talk about it, you can't discuss it, you can't mention it, you can't do a publication on it, you know, or anything that would bring disrepute to either the courts or the child in question. So basically, from the facts, or from what is alleged, is that Fatou Touray of Kir Fatou and Tima and a few other people, when this matter was hot, you know, the issue of this custody, you know, battle between you know, a particular gentleman who lives in the States and another person who was I think his ex-spouse, his ex-partner. So it was a very you know, it was sensationalized on the media, especially on social media, where it was seen as if it was one guy trying to take, you know, custody and take a child from another partner, that kind of thing. So the person in question has brought an action. But I want to talk about this private prosecution, because I feel private prosecution is something that is not really well known in the Gambia. It's not the route that has been taken, you know, it's not a very common route. That, so our jurisprudence doesn't really have a lot of matters that you know, private prosecution was you know, where the counsel, you know, the person, the individual has gone through that route. Usually it is done through the police. So of course I know everybody saw when Fatou Touray came on air, and she did mention that, you know, she was taken to court, she was not served, she was not given anything, she wasn't giving any documents, she was in, you know, it wasn't brought to her notice, and the charges were bogus, and that it is, you know, it is just a it is just the charge, it is just the, you know, just something to actually, you know, defame them and things like that. So she went on and on and on. But where they made a mistake and where they failed to realize and understand that really it was not about that, you know, the warrant of arrest, or the bench warrant that was issued by the court, was not an arrest warrant that was meant to take them to mile 2, as she alluded in her video. That was absolutely wrong. Now, the difference between a private prosecution and a prosecution by the police is just one difference. One difference. And that difference is that one is being done by the police, you're being prosecuted by the police, and the other, you're being prosecuted by a private legal practitioner. I'll repeat. In criminal prosecutions, there are two angles. You either have a criminal prosecution where you're being prosecuted by the police or the state, or you have what you call private prosecution, where the prosecution is done by a legal practitioner. It is you know, it is the same thing. It is the same thing. The same route, just as how the police would prosecute you based on a charge sheet, and you know, everything, how you'd be granted bail, brought before a court, that kind of thing is the same thing. The only difference is one is being done by the police and the other one is being done by a private practitioner. Now, what would happen is this private legal practitioner would have to go to the courts, and he will seek from the court, you know, leave. He will ask the court for permission to take on this prosecution, to say, you know what, but there are certain ingredients, there are certain things that must be met before you can make an application to the court for private prosecution. The first thing that you would have to do is to show the court that, okay, because remember, it's a criminal prosecution, huh? So which means whoever is being prosecuted based on a criminal charge, something that they have done that they are criminally liable, allegedly criminally liable for. So usually, and rightly so, it is the police who prosecute criminal matters, or the state. So what you would have to do, and this is a safeguard, it's a safeguard in the laws, which basically tends to create some sort of a check and balance, you know, checks and balances on the police. So for example, let's say the police now, so let's say somebody has a complaint against Melville, but Melville is very, very cool, or Melville is a figure that the police are not willing, they're not willing to actually go after Melville and arrest Melville and or charge Melville. So in this instance, you know, you go to the police, you lodge a complaint, you say, I have a complaint against Melville, but still the police don't want to charge Melville. What are you going to do? You can't do anything. You cannot go and arrest Melville. You cannot go and charge Melville for a crime. So this is why the law have provided for something called private prosecution. That way, where the police are unwilling, the two principles, unwilling to actually bring a charge or bring or go and apprehend an alleged accused person that a complaint was lodged against, or they are unable. So you have the unwillingness and the unable doctrine. Unwilling is that they can prosecute, they can charge the person, but they don't want to do it. They just don't want to do it. They are not willing to do it. And unable is where they cannot do it. You know, for various reasons. There are various reasons why they can't do certain things. So for example, if you want to go, I'll give you an example, a very crazy example. Right now, let's say you have a complaint against the Inspector General of Police and you want them to charge the Inspector General of Police. And you go to the police station and say, good afternoon, I want to report to the Inspector General of Police. This is where he lives. You have to go and arrest him. You're most likely going to be faced with very, very stiff resistance from doing so. So, however, if you can go to the court and show the courts that, hey, you know what, I have a matter against Fatou Touray of Kir Fatou, and it seems that the police are not wanting to go and arrest her. So the courts gave an order. The courts gave an order where this order was shared with the police. I think it was sent to the Inspector General of Police, but still nothing was done. She was neither arrested, she was neither cautioned with regards of the alleged offense. So they decided to now go through the route of private prosecution, private criminal prosecution. So they go to court. They take leave of the court, permission from the court, show the court that, hey, you remember this letter was sent to the police, but they haven't done anything. We've made a complaint. The police have not arrested her. The police have not charged her. The police have not done anything. And that, if you satisfy the court that the police don't want to do anything, then the police will then now give you the right, the legal standing to institute private criminal prosecution against these individuals. But you must have, so you would have satisfied the courts that the police are not willing to do whatever it was that they were supposed to do. Now, when you do that, you now become the prosecutor. Once that leave is granted, the the private legal, the legal practitioner now becomes the prosecutor. He is the one that is going to prosecute these individuals, and he's the one that will actually show cause that these individuals, the charges that have been brought against them are really, you know, just prosecute, are really, you know, they're substantive, they're you know, they can substantiate the charges and things like that. So basically that is what is done. Now, you see the part where Fatou Touray mentioned that, oh, I was not served. You can't, the police would never serve a person to go and arrest them, do they? They don't serve you. The police don't serve you. The law provides for them to call you, to, you know, tell you that you're wanted at the police. They will ask you questions, and then, of course, they will charge you. If they charge you, they have a right to remand you, to detain you for like up to 72 hours. And of course, after the 72 hours, they must bring you before a court of law where, you know, you'll be formally charged, or they will release you on bail. Now, so when there's a private prosecution, you don't have to serve that person like notice. You don't have to tell that person, oh, I serve you, what do you say? No. It's just a criminal matter, just like the police would do. So there's nothing about serving them. There's nothing about giving them time to reply. There's nothing about sermons and stuff. It doesn't arise in this matter. It is a criminal matter being prosecuted. The only difference is one is the route of the police and this one is a private one. So you don't need to serve them nothing. But what you will do is the private prosecutor will now make an application to the court for an arrest warrant. But this arrest warrant is to bring them. The warrant is to bring these accused persons before the court, so that the court can now read the charges to them to say that you have been charged for this particular offense, or you are here because so and so has filed a complaint against you. They've made an application, asked for leave to actually bring this matter to the courts and stuff like that. So contrary to what they all thought, or the explanation that was given that, oh, this is a bogus charge. No, it is not. This is just what a police would do when a complainant goes to the police and complained that we have a matter. The Children's Court expressly states that you cannot mention this matter, you cannot bring it on social media, you cannot discuss it, you cannot seem to take sides, you cannot do nothing about it. We all know how this matter was when it was really in the public domain. I mean, there were so many. In fact, me and late Mbye, God bless his soul, had a very heated debate where he said to me that I was scared of the Chief Justice, or I was siding the Chief Justice, because I refused to partake in the bashing of the Chief Justice and the bashing of the lawyer that was representing the plaintiff in this matter, because the lawyer, the lawyer is the son of the Chief Justice. I refused to be dragged into such petty squabbles. I said no. I resisted it. He tried to get me to give a statement or talk about it, or you know, say something, you know, against the person of the Chief Justice, to try, because what they were trying to do was to paint some sort of connection that, okay, because his father is the Chief Justice, that's why they were taking advantage of it. You know, people do not take time to read in the Gambia. Gambians don't like reading. Gambians don't like research. They don't like to go ahead and find out. You know, it's just what one person comes and say. They take it, they run with it, they amplify it, they make it bigger, they yoker it, they add pepper, salt, make it spicy, you know, add a few things on it, give it some sort of, you know, whatever it is they do. So basically that was what they were doing at the time. It was a very, very, you know, hot topic on social media in Gambia at that time. So going back to what I was trying to say, so you don't really need to summon the person or give them cause to answer, say, oh, come here and say this. No, you don't do all of that. It's a criminal prosecution. The court will now give, you know, issue the warrant, and then this warrant now will be served on these individuals, or they will be informed. So, for example, if you listen to Fatou Touray, she did mention that she was called. She was called and asked to come before. She was asked to come to the courts and then explain herself to the courts, or appear before the court, basically. So really, if they wanted to arrest her, if it was a warrant for arrest that, you know, they were alluding to, that they wanted to take them to mile 2, they wanted to that, nobody would call you until you come to court. They will just come and scoop you up wherever you are. They'll call you, "Oh, good afternoon, Mel, where are you?" And then the next minute, you know, there'll be police officers that will come. They just take you straight to mile 2 remand, and they leave you there until the next adjourned date, and then they bring you before the courts. That's what they would have done. But that is not the purpose. The purpose of the arrest warrant is really to bring you to the court so that you know that there are charges before you. Now, if it was a prosecution where it was the police that was handling it, what would happen is, 2 things would have happened. It's either one, you would have been in the custody of the police because they would have arrested you to tell you that they are charging you. So you would have been in the custody of the police. So the police don't need to give any more notice. They don't have to struggle to take you to court. You're already in their custody. They just drive you or walk you across to the Banjul Magistrate Court, or they just take you to court. It was as simple as that. The second thing is, where you were not in the custody of the police, it would mean that the police had already granted you bail. So when they grant you bail, I mean, you would have satisfied certain requirements, so they know how to get you. They will just call you, tell you, come and report, and then you come, and then they walk with you to the courts. So it was very, very simple, you know, something simple like that. But because this is a private route, because you're taking the private route, because it's not the police prosecuting. The lawyer cannot just walk to your house and scoop you up and say, "Hey, Melville, come on, let's go to court." You know, they won't do that. They won't do that at all. You know, so what will happen is the police, the private prosecutor will now make an application to the court for a warrant. Now, the court now will give this warrant. They will grant this warrant. You know, the order would be made, and then, of course, you will be informed. So, of course, when Fatou Touray was informed, they told her, "Come to court." She drove to court. At first, she said, I think at first, if you listen to her, she said she wasn't going. But I think somebody explained to her and said, you know, this is serious, the gravity of it, and said, "You got to go." So she went to the court. And when she went to the court, of course, nothing happened. The court they did not remand her. They didn't take her to mile 2. No, she was just brought to court. Of course, she was told about, you know, about the charges and stuff like that. And then she was granted court bail, which is the same thing that would happen in a criminal prosecution where the police are prosecuting. The police will arrest you. The police will charge you. The police will take you to court. And once you're in court, then you will be granted a court bail. Because the police bail stops when you appear in court. So you can be on police bail, and then the court will now decide to extend the police bail, or by virtue of it, you know, metamorphosing into a court bail. And then, of course, that is exactly what happened in the instance of Fatou Touray and others. So it was the court. So, you know, a lot of people rushed. You know, a lot of people rushed to say that you know, or the state was going again. You know, this was people using their powers, people using their connections. No, it was nothing like that. It was just a very simple matter. A very simple matter that really, it's just like me going to lodge a complaint against anyone. And the only distinction in this matter is that one was done privately, where the police, after the complaint was made, seemed not to want to do anything about it. So it was decided that, hey, the best possible action is to institute a private criminal prosecution. So that was what happened in that instance. So, of course, because it's private, doesn't change anything, as I've established. The only distinction is that makes it a private criminal prosecution is the fact that it is not the police or the state that is prosecuting the criminal charge. It is a private lawyer. So obviously they came to the courts. Of course, I think the matter was mentioned last week. They were brought to the courts. just like you would do any accused person. They went into the accused box. They were read, you know, formally. You know, they asked them, you know, what the charges were, and not what the charges were. They read the charges to them. Read the charges to them, and of course the charges were that of the prohibition of publication of proceedings of the children's court, or the mention of a child that is in the you know, really the subject of the proceedings in the children's court. So this was what they were charged for. So I know a lot of people said, oh, they were charged for this. They wrote stuff about Sam Fati, or they said a lot of bad things about him, or that. No. That is a civil matter. That cannot be a criminal matter. So the fact is, what was out there, the truth was not being said as it is. It was being sugar-coated. But this had nothing to do with what they said. What they said about Sam, or publication of very incriminating things against him, or bad things, or things that were bad, or that kind of thing, that is for him to institute you know, civil, you know, go to the courts and you know, go to the courts and try to sort whatever civil wrong was done to him. But this is squarely based on what they did that was against the Children's Act. You know, this was what they did against the against the Children's Act. So basically, they have been alleged. It is alleged that they have violated provisions of the Children's Act, where it is deemed that that violation is a criminal offense. So this was what happened. So it has nothing to do, or they said this to Sam Fati, they said this, they said no, it was not done. You know, it's just, those are just sensations. Those are just things that, you know, people would say, just sensationalize things. So everybody was saying what they want to say, and no, it's not like that. No law has been used to frustrate anyone. They have not used any law by force or using power. No, this is provided for in our laws, and it was granted by the court. So, to give a rundown of today's event, they were brought to court today. And of course, today was the first time that you know, they were brought before the court. In fact, the last proceedings, they were asked. I think Fatou Touray she was asked to give her bag. You know, give her bag, you know, hand over her bag and her phone, because, you know, I think they just wanted to show the gravity, the seriousness of this matter, that, hey, this is not a civil matter. This is a criminal matter. You are an accused person, and that, you know, you have to abide by all the legalities that are there, you know, to ensure that a criminal trial is prosecuted. And of course, you have a right to defend yourself with all you've got, all your might. And of course, I think Fatou Touray had mentioned in her program or in her show that all the charges were bogus, and said something like that, or she will fight her way, she can afford a lawyer. So this was brought to the attention of the courts. You know, this was brought to the I don't understand. So so this was brought to the attention of the court, and the court took it seriously. You know, the court, they were seriously warned that if they speak on this matter publicly on their platforms, or talk about it, or report on this matter, or try to jeopardize the matter, you know, that their bail would be revoked and they would be kept in remand. So they were seriously warned, and I think they now understand that, hey, this is serious. This is a criminal matter. It's a criminal trial. You know, it's just that it is being prosecuted. You have a prosecutor who is a private legal practitioner, but he has taken leave of the court, and he has the same powers as any prosecutor in the Gambia, be it the state prosecutor or the police prosecutor. He has the same powers. So they were strictly warned that this is no joke. You cannot do that. You cannot seem to make such, you know, big, you know, false accusations, really, to say that this was a witch hunt or this was that. No. So they were warned seriously, and then they were asked to take their plea. So today, of course, they took their plea. They both pleaded, the two persons that appeared, they both pleaded not guilty to the charges. And of course, a very interesting thing happened, because after they took their plea, in court, you know, the no guilty plea or not guilty plea, then of course their lawyer, who is also a very brilliant, phenomenal lawyer, the defense lawyer, got up and you know, made an objection that the charge sheet was what's the right word? There was a defect in the charge sheet. There was a defect in the charge sheet. So of course he made his argument, very, you know, robust argument. He cited the law of why the charge sheet was you know, it was there was a defect in the charge sheet. But of course the lawyer on the other side too, a brilliant lawyer, the prosecutor, also you know, argued and responded, and of course cite provisions of the law that say, you know, states that the objection to the plea or the charge sheet must have been done before the plea is taken. The plea is where they ask you, are you guilty or not guilty? And then you say, yes, I'm guilty. If they had said, yes, I'm guilty, then the matter is finished. It's just concluded. Pam, pam, pam. You know, they just go ahead and do a ruling or a judgment. But where you say not guilty, you know, they would ask you, they would always ask you, because that is what the rule of law, you know, it's very clear that people must know what they're being charged for. You have to read the charges before them, like in any criminal matter. So they were read the charges, and of course they took their plea. You know, both of them, both Fatou Touray and the other lady, Tima, both of them said they were not guilty. They pleaded not guilty. But then after they had taken their plea, when they had already said not guilty, that was when their lawyer now, I think, saw or made an observation, and then of course brought it to the attention of the court. But the prosecutor was also on his feet to say that no, that is not what the law says. I mean, you had the charge sheet. You heard what it was. They read it to you, and then you decided to plead. You said not guilty, or you said guilty. The mere fact that you have entered your plea shows that you understood the charge sheet. You know, shows that you understood the charge sheet. So you cannot now raise that plea. So that was the argument. So both lawyers defended robustly, because you have to. You must. It's a very interesting case that I think people should follow, because you have two brilliant lawyers that are really taking the matter. The defense lawyer of Fatou Touray and Tima is a very highly respected lawyer, a senior lawyer of the Gambian bar. Very good lawyer. The prosecutor is phenomenal, absolutely brilliant lawyer, very good criminal lawyer, very diligent, knows his stuff, very good. So really now, they both made their argument, and of course the court would have to give a ruling on that, whether, yes, the court will agree on the side of the defense to say that, yes, there's a defect in the charge sheet, and then, or to say that no, you know, the objection is you know, cannot hold because of the argument of the lawyer, of the prosecutor on the other side. So that was basically what happened, and of course the matter was adjourned for ruling. So this was that matter, the matter with Fatou Touray and you know, on the private criminal prosecution. So that was that. Now let's move on. Yeah. So the second bit is the issue of Sainabou Mbye. So of course today, Sainabou Mbye was brought to court, and I've just had, you see, if you guys can tell, I'm a bit tired. The reason why I'm a bit tired is that I have had the most, oh my God, I've never had such a serious debate. I've been debating with a High Court judge. I've been debating with a senior magistrate. I've been debating with a few lawyers on this issue of Sainabou Mbye. I have a totally different idea and understanding of the law, opposed to what is happening. And of course, my inspiration is drawn from looking at the law here in England, the procedure, and of course, you know, our laws is patterned according to English law. And I've looked at the law in Nigeria, in Kenya, and so I was making a very serious argument where I even had to consult somebody who is who is a Supreme Court judge to just ask these questions, you know. So really, I like to research, I like to read, I like to get into these debates because you learn. So a lot of things, in my belief, a lot of things is done in Gambia. It is not based on the law. It is just based on practice. It is just a culture. It is just things that people have done over and over and over and over again. To a certain extent, if you're not careful, it looks as if it is the law. It seems as if it is the law. So for example, one thing, I'll give you an example. So there's this business where the police, imagine the police are in Gambia. The police have an entire legal department. So the police know the law, they know the hierarchy of the courts, they know the powers of the courts, they know and understand the jurisdiction of the court. So when I say jurisdiction of the court, because I don't like to, if you guys notice, when I talk, I don't like to use all these big legal jargons. I mean, it doesn't make sense. I see a lot of people do that. When they're writing about the law, all they do is copy paste. They go and copy big sections of the Constitution or big sections of the law, and they're trying to impress non-lawyers. You understand? It doesn't make sense because they don't understand you. So what I try to do, I try to break the law down so you understand simple everyday language, so you understand what the law is, and you get to understand what I'm talking about. So I don't have to come and impress and start using massive legal jargons that you have to go get an Oxford dictionary to open and try to find the meaning of things or these procedures and rules. No. So when I say a court does not have jurisdiction, what it simply means is that the court does not have the power. It does not have the legal standing. The law has not given the court that right to hear a particular matter. So they don't have, when a court lacks jurisdiction, it means that court does not have the legal standing. It means that court does not have the legal power to hear a particular matter. So going back to things that are being done in the Gambia, that it's not based on law, it's not based on any law, it's just a culture, it's just a practice, it's just something that they have done over and over and over again to a point that it starts to become law. Because you need to understand that our law is influenced, our jurisdiction is influenced, our jurisprudence rather, our jurisprudence is influenced by a lot of, for example, we had Nigerian lawyers, we had Ghanaian lawyers. So you have the influence from other countries as well, and then you have the influence of countries where things were not so good. There was a dictatorship, you know, in place. You have executive orders. You have things that were directives from the state. So, for example, you'll be at work, State House will just call you and tell you do something, and you start doing it and doing it. After a while, it looks like it's the law because that's what they do, and then everybody accepts it. So, for example, you go to the police, like Sainabou Mbye. Sainabou Mbye went to the police. She was charged. She was arrested. Now, we all know, all the police officers that took Sainabou Mbye to the magistrate's court knew fully well that the magistrate court did not have the jurisdiction to hear that matter. They knew that. They knew that the magistrate court did not have the jurisdiction to hear Sainabou Mbye's matter. Every single police officer knew that. But the police officers do not have the right of audience in the superior courts. So a police officer cannot appear in the High Court to prosecute a matter in the High Court. They only have a right of audience in the magistrate's court. So ordinarily, in a country where the rule of law is respected, in a country where, you know, democracy and its ideals is valued, in a country where the constitutional rights of an accused person is respected, it's fundamental, it is guarded jealously, what would happen is, of course, the police would now liaise with the state, because remember, it's a capital offense that she was being tried for, or she was being charged for, because manslaughter is a capital offense. A capital offense, what I mean by a capital offense is any offense that attracts either life sentencing or the death penalty. So it's a capital offense. And the magistrate's court, by a practice directive from the Chief Justice, do not have the jurisdiction to hear such matters, because all such matters must go to the criminal court, the special criminal court, or the High Court. So basically, the police knew that the magistrate court do not have the jurisdiction to hear Sainabou Mbye's case. So when they were going to court, they knew that. But it has been practiced for such a long time that it is now standard police procedure. So the police now took her to the magistrate court, because they know when they take her to the magistrate court, the magistrate will not, you see, the police cannot take you to remand. I want to explain. The police can only detain you. It is called a police detention. Police detention. So the police would only detain you in the cells or stuff like that. That is it. I'm not too sure. I don't think they have the power to detain you and take you to remand. No, remand has to be an order. It has to be an order that should come from, I think, a level of a magistrate or something like that. So they knew, the police knew that the magistrate does not have the power. But the police, of course, at that time knew that if they take Sainabou Mbye to the magistrate's court, the magistrate can do two things. One is to declare that he does not have, or he or she does not have, the jurisdiction, the right, the legal standing to hear a capital offense, a charge of manslaughter. And therefore, the magistrate will refer the matter, the file, to the Supreme Court. They would take it to the Supreme... What am I talking about? I'm talking rubbish. Not the Supreme Court, to the High Court. So the magistrate will send it to the High Court. Of course, it will go to the Chief Justice. And the Chief Justice will now assign who will hear this matter. But the funny thing is, and which is always being done, is that they would take you to the magistrate's court, because they know that the magistrate will now send you to remand. So the magistrate will send you to mile 2. So by the time the file is being taken back to the Chief Justice, the Chief Justice now decides to assign that matter to a court, you would have gone to mile 2. So that is standard procedure that they do. But the police could have liaised with the State Law Office, which is the Ministry of Justice. They could have filed a Bill of Indictment, and right from the police, that person would be taken to the High Court, the court that has jurisdiction. So this is it. So this is a tactic that the police have always used, and now it seems as if it is law, where you will be charged, and once they know that they don't want to give you any chance of having bail, they will send you to the magistrate's court. The magistrate does not have jurisdiction, so the magistrate will commit you to remand, mile 2, send the file to the court that has jurisdiction, and you will be in mile 2, like Sainabou, she was in mile 2, whilst your file is being assigned to a particular High Court judge. And then today, the case was up for mention. Mention, what it means basically is you just bring the case and people just come. They just appear. So the lawyers, that's the first time the courts will see the lawyers, the defense, to say, yeah, I'm the one representing this person, and that kind of thing. So today, we saw that Sainabou was brought to court. And of course, when they came to court, Sainabou and the other persons that are being tried, the lawyers, I think it's Sagar and Kombe Gay, Counsel Gay and Counsel Thomas. Oh well, she's not Thomas anymore. She's married. Chum, yeah, Counsel Chum, yeah. I don't know if I pronounced that. They represented the accused persons, so that is Sainabou and stuff. And of course, you gotta take it that they're brilliant lawyers, you know, very brilliant lawyers. Counsel Gay is wonderful. Counsel Gay is the daughter of Antuman Gay, and Antuman Gay is one of the senior Gambian lawyers. You know, he's part of the creme de la creme of Gambian lawyers. So very good lawyer. And Of course, she's also a phenomenal lawyer, Kombe. She was trained by her dad, phenomenal person. Sagar is absolutely fantastic. I mean, a lot of you know Sagar because Sagar was the counsel at the TRRC with the short hair. So a lot of people know her. Brilliant lawyer, phenomenal lawyer. So it's going to be a tough one. I have always made my position known that I don't think, and I've written this, I don't think there's much appetite based on my understanding on, you know, the state on actually pursuing diligently and aggressively the charges of manslaughter against Sainabou. I don't believe that. I mean, this is my honest belief, my honest opinion. And I don't believe it because it just defies logic in my world, you know, because of course you have the criminal trial, of Bob, where Sainabou is a witness. You know, she was, I think initially she was the complainant of the police. Her sister is in her custody. She's been working with the state to actually, you know, to help them in securing a conviction in that matter. And now there's another matter that is before the court where Sainabou is the accused person. And if the state were to diligently, successfully prosecute Sainabou, it will have, I believe, I don't know, this is my own understanding of the law and being honest and sincere with my analysis, that really it would be it would be so difficult, because I believe the outcome of this case will have an impact on the other case. Because where you successfully prove, you know, manslaughter, you know, and then you have to lay the foundation for that case to show such magnitude of negligence on the part of Sainabou, and then of course you know the child in question in this matter was the subject, or still is kind of in a way the subject of the matter on the rape trial against Bob Keita. It's a bit complicated for me. I can't see how the state would be able to develop, because remember, yes, we all refer to the state, but you know, the state, they're human beings working there, you know. The state council are all humans. They have a heart, they have a conscience, they feel, they are not oblivious to what is going on social media. They're not oblivious to the cries, the public outcry of this matter. You know, they're not oblivious to what is happening. You know, the national call for a quick, effective, transparent, fair, you know, justice delivery with regards to this matter. So they see all this. So they're humans. So really, I don't quite understand. I don't quite know how it will play out. Where, for example, today you saw, I mean, I thought that was something I should mention, that it was, for me, that was, I think in another country, to be honest, in another country, I don't think that would have been done. It is not illegal. It is not illegal, but I think it's against best practice, where the lead counsel that has taken over the criminal trial of Bob Keita, lawyer Patrick Gomez, a brilliant lawyer, is now the lead counsel in the Sainabou Mbye manslaughter trial. The same person. You see, and this is the same person that would argue in that matter on the testimony of Sainabou Mbye. Because the lead counsel would want to show the court in the rape trial that, you know, Sainabou Mbye was a very credible witness. They would want to depend on her testimony to advance and to show cause why Bob committed the offense. And now the same Sainabou is the one that Patrick would now have to convince the court that, hey, you know what, she's the one that deliberately did this. It's manslaughter. Well, not deliberate, but manslaughter is an accidental death. But I just feel that it's going to be a very, I don't know how they're going to do it successfully. So I would not be surprised if the charges of manslaughter would be changed at some point. I wouldn't be surprised. I wouldn't be surprised if the state does not pursue this matter, you know, in a very diligent or aggressive way. And of course remember you have two brilliant defense lawyers who will show, you know, they're not going to sleep. these are lawyers that once they take up a matter, they will, I mean, I know, I've not dealt with I know Sagara, I know of her work, I've not dealt with her personally. I have dealt with Kopege, and I can tell you she will aggressively pursue this matter. She will not relent. She will go all out. So, you know, it's two brilliant defense lawyers. They will show the court that, hey, you know what, this bit of this charge of manslaughter cannot hold. They will do everything in their power to defend Sainabou, you know, within the law. So really, I don't know how this will play out. It's very interesting, very interesting. So I don't know. So that was what happened in court, and then of course the state informed the court that they have not yet filed the Bill of Indictment. Let me see how I can explain the Bill of an indictment. An indictment is basically the charge, the formal charge of a formal criminal charge against an accused person in the superior courts, in the high court. So in the magistrate's court, you will have a charge sheet. So I just explained to you about Fatou Touray and them. So their charges would appear on a charge sheet. Now, in the High Court, you have what you call a Bill of Indictment. This is usually filed by the state. So this is what really formalizes, if you can take it that way, it's what really formalizes that you know, formal charges have been brought against an individual. You know, criminal charges have been brought against an individual in the superior courts, in the high court. But we see today that the state has not filed an indictment yet. This was what came out of today's proceedings. The state has not filed an indictment. And then the bit where I said I had a very serious debate and argument with, you know, a few lawyers. One is a high court judge. The other one is a magistrate, a very senior magistrate. And then some other lawyers, was that I believe that this business of the state you know, going to court and saying that they want time, they need time to prepare the Bill of Indictment, while an accused person is already in jail, in custody. I don't believe it is I don't think it is right. I don't think it is right. I don't think it is legal in a way. I've checked the law because my friend was arguing and he sent me the law. I've looked at it, and when I looked at the law and I read it and I scrutinized it properly, from my own understanding, I don't believe that's the appropriate section that goes with the argument that they were making. So for me, I am calling for a fair criminal justice system where Sainabou would be availed the same equal measure as Bob. They would all have fair, you know, trial. They would be treated fairly before the law. They would be treated right. Because today is Sainabou, yesterday was Bob, tomorrow it will be somebody else. So you cannot, and this is what I keep saying, and I see a lot of things that are going on social media. You cannot advocate. Of course, I will continue to point out the hypocrisy, because you see a lot of people now chanting and defending Sainabou. Now because they're defending Sainabou, it is now that they are now complaining about the justice justice delivery system in the Gambia. I think that is hypocritical. I think that is false. I think that is not genuine, because we were advocating. We were not coming out just supporting Bob. We were not saying, no, oh, Bob did not commit the offense. We've never said that because we were not there. We were not present. What we were saying is Bob has been unfairly treated. What we are saying is that Bob deserves to have a fair trial. Bob deserves to have his fundamental human rights as enshrined in the Constitution upheld. And now what we are seeing, and what the argument I'm making is that the state not filing, I mean, the state could have adopted, I mean, in my opinion, the state could have adopted the charge sheet that the police, you know, took to the magistrate's court and file an indictment, a Bill of Indictment on those charges. And if further investigations show that really there are more substantial evidence that warrant a more serious charge, then they can continue, they can do so. They could amend the Bill of Indictment. They can make an application to amend that. But now, for me, in my own legal understanding, there is no, the charge sheet. Remember, the police do not have a right of audience before the superior court. So as far as I'm concerned, a police charge sheet does not have procedural legal standing before the High Court. What formally brings a person before the High Court to show the court that this person is before me and this person has been charged of a particular offense is the Bill of Indictment. The Bill of Indictment that will be filed by the state. Now, this was not before the state, and therefore that was why the defense counsel of Sainabou made an application. They made an application before Justice Jaite for bail, that the accused person should be granted bail while the state go on and sort their business out, because the state did inform that they needed 2 weeks before they could file the Bill of Indictment, and the defense objected and said, you know what, of course you need 2 weeks to go and sort yourself out. You cannot keep the accused person in remand whilst you go and sort yourself out, whilst there are no, technically there are no formal charges, and this is my own understanding, before the High Court. So let the accused person go. When you have proper charges, you have your formal charges, you have your bill of indictment, then you bring them. And this is the same argument we made in the issue of Bob. Same argument. Don't charge the person when you don't have prima facie evidence against the person. Don't. You cannot keep a person for 2 years in remand whilst you go on a fishing expedition to get evidence to nail that person. You cannot do that. This is the argument that we have made. And this is why we say the criminal justice delivery system in the Gambia is flawed. The way the scale of justice tilts against an accused person is unfair. It is not balanced. And now we were advocating that, passionately, and within a week or two, we have seen how it has twisted. We have seen how it had taken another turn, where now you see allegedly, I can't say, what am I talking? Not allegedly, but you see the feminists now, some of what the individuals that identify themselves as feminists or whatever amounts to that, are now advocating for a justice delivery system that is fair. So you see how the hand of fate can change things around. When we were calling for it, when we were calling for a justice delivery system that is fair, they said we were advocating for Bob. They said we were Bob supporters. We were labeled as Bob supporters. And all of a sudden, Sainabou, who they have been advocating for, is feeling the brunt, of the legal, the criminal justice system of the Gambia. And now they are saying, I see them crying all over. All over they're crying. Writing, up and down, crying. But this was what we were advocating for. This was what I have always been passionately advocating for. To have a justice delivery system that is fair to all. So that where a Bob comes into it, where a Sainabou comes into it, they will all be treated fairly and equally before the law. Where the law would not go after a person without proper investigations and evidences to warrant and all that would commensurate with that charge. This is what we have been advocating for. Nothing more, nothing less. This is what I have been advocating for. Nobody would say that they saw me insulting Sainabou Mbye. I have never insulted her. I don't know her. Why would I insult her? Nobody would say I have ever said anything about Mama. In fact, for me to say the word Mama is very difficult for me. I don't even say it. I don't mention it. What I have consistently and always said is that both of them deserve justice. There's justice for Mama, the victim, the alleged victim. And of course, the accused person also deserves justice. Because where a matter is prolonged in court for nearly 2-3 years, the justice system is not also fair on the accused person, because the accused person has no closure. No closure whatsoever. So where even though the system looks as if it seems as if it is more or less against the accused person, but then when you look at it critically and give it a very, very, very thorough, in-depth look, you would realize that it is just as bad for the victim, for the alleged victim. Because whilst Bob, the only difference is Bob is behind bars. Bob is caged physically. But the victim is mentally caged. That is if the victim is credible and if the victim is really a victim. We do not know now. We do not know because nothing has been tested before the courts yet. So we don't know. They are not, you know, there has not been a verdict. But obviously, if truly that victim is a true victim, then that child is, even though Bob is physically restrained within the four corners of Mile 2, this alleged victim is restrained mentally, emotionally, and psychologically. So you see how the justice delivery system is not favorable to both. And then now you're seeing the judicial system. You're seeing a judicial system where you see the person you've been advocating for being brought to court, and where they tell you that there are no evidences before the court. None whatsoever. The only evidence that they have, of course, which I'm sure that was the line that Patrick was going to go, is that the fact that the child has died. But even that, I don't think there's anything. Maybe there's no Bill of Indictment before the court. So you would have to file a Bill of Indictment. You will have to attach the death certificate. You would have to attach the pathologist report. These are the things that show and go to support the Bill of Indictment, to say that yes, indeed, a child has died. Somebody has died. Somebody has died. So you just don't come and file a Bill of Indictment without anything, nothing, to show and demonstrate to the court something that would, you know, prima facie establish why those charges are there. And this is what we have been advocating for. And I'm sure people are now seeing how Sainabou being in remand is as a consequence of the rotten system that we're speaking about. The system is rotten. The system is flawed. The system needs an overhaul. We have laws, very archaic laws that have been outlawed in other countries, in other jurisdictions where we took the laws from. Some of the laws in our statute books, if you come to England and mention those laws, they will clap at you. They will clap at you. And that is why when you advocate for something, whatever you do it honestly, you do it sincerely, you do it with all your heart, with all your might and soul, and do it in the right way. Because you don't know when it's going to turn around and when it's going to bite you. You don't know that. So when I was advocating, they thought I was going, oh, you're a Bob supporter. What makes me a Bob supporter? What I have said is I have called for the freedom of Bob based on what we know. It is my right to do so. It is my right to do so. I am not trying to derail the prosecution of Bob. I am not trying to influence the outcomes of the court. I am not trying to influence the judge. No, I have not done that. I have commented, I have made commentaries based on my understanding of the proceedings of the court. My opinion on the proceedings of the court. That is what I have done consistently. Let somebody call me and show me a video or a write-up that I did, that I wrote against the accused person. No, everything I have said are things, are statements of fact that have been said in court. Nobody would tell me that the accused person, it was not established in court that she had a boyfriend. Of course she had a boyfriend. Nobody has disputed that. This is what I have said. This is what I have said. I have not said anything that is prejudicial except if their feminist mind, which I don't believe they have the right level of IQ to understand what I'm saying, but if they admit and are honest and are sincere, they will know that I have never advocated or tried to influence anything. What I have advocated passionately for is that justice must be done in a way that is honest, in a way that is sincere, in a way that is true, in a way that is proper, in a way that is impartial and timely. Yes, this is what I have advocated for. And it is what I will continue to passionately advocate for. Passionately advocate for. A justice delivery system that will protect an accused person, just as it would protect a victim. A justice delivery system that will recognize the fundamental rights of the accused person, just as it recognizes the fundamental right of the alleged victim. A justice delivery system that will be fair to both. a justice delivery system that will dispense, justice in a very fair and transparent way. This is what we're advocating for, and in a speedy manner. A justice delivery system that would not be held solely on the whims and caprices of a judge, of a judicial officer, where they can do anything, and they can do anything, they can frustrate anything, and we would have to bow down and accept that yes, this is the judicial officer, we cannot comment, we cannot say anything. No, that is what we're kicking against. The world has phenomenally moved. The world has phenomenally moved. You had a time where the law courts, judges, lawyers, prosecutors were seen to be of a certain cult, where you cannot touch them, you cannot name them, you cannot mention, you cannot comment, you cannot do anything. The world has phenomenally moved. We live in an age and day of social media, where social media is influencing the outcome of everything, whether you accept it or not. Where social media is a massive influence in geopolitics, in globalization, in international law, in governance. Social media is an active participator in this. Social media has influenced the change of government. We have seen the Arab Spring. We have seen the Arab Spring. Social media cannot be underestimated. And the laws in other jurisdictions are progressing and evolving to accommodate social media. It is not for social media to accommodate the law. It is not for social media to accommodate the law. I saw a letter that the president of the Bar Association wrote. It is not for social media to accommodate the law. It is for the law to understand. It is for procedures to understand and accommodate the pivotal role that social media plays in our world today. A day-to-day activity is premised. It is really built on social media deliverables. So we need to understand that social media is crucial. Social media is key. Social media is showcasing. It is making prominent the shortfalls and the positives of everything, especially within our justice delivery system. This is not the time. I am not in the Gambia. I am not in the Gambia. But because of social media, I can tell you verbatim of what is going on in the courts. I can tell you. I am hearing real time of deliberations in court because of the presence and effectiveness of social media. We are not in the colonial era. We are not. And it is high time that we begin to look at our procedures. We begin to look at the dispensation of justice. We begin to look at our judicial arm in a way and manner that encompasses and recognizes the very crucial and important role that social media plays in our day-to-day lives. So, the matter has been adjourned. And of course, they made an oral application. The defense made an oral application, but the judge was not having any of it. He has asked them to go and make a formal application on notice where they would serve the state prosecutors, and the state prosecutors would have the right of reply. So I can tell you authoritatively that on Friday, Sainabou is not going home. It's not good. She's not going home. Just like I've told you with Bob that Bob was not going to go home, where people were saying, "Oh, we're going home with Bob." I told you. So this is just how the justice delivery system is. So Sainabou is not going to go home because the state will make an application. The defense will file an application, and of course the state will be giving, I think it's 48 hours to reply. So the state will reply, and then the state will reply. Then there will be an adjournment again, where the court would rule. Where the courts would rule. So that would take maybe another week, maybe another 2, depends on the adjournment. Remember, adjournment has to be agreed on both sides. So where the state has, the defense wants a 2 days adjournment and the state is not available, the state will say that we are not available. We're available in 2 weeks. in 2 weeks, in 1 week. And they will have to accommodate the availability of the state prosecutors. And now you would see why we are advocating for an overhaul in our judicial system. This is what it is. So to all those feminists that are watching me on the corner, on the side, through the window, you now see why we're advocating. This is what we're calling for. And this is what we're doing passionately. We are not supporters of Bob. We are supporters of the discrimination against Bob. We are supporters of the partiality of the justice system against Bob. We are supporters of the wrong that have been meted against Bob. We are supporters of what we have seen that amounts to a failure in our justice delivery system against a young man. This is what we are supporting. This is what we advocate for. And this is what we are supporters of. What we stand for, rightly so, is justice. A free, fair, transparent, effective, and speedy dispensation of justice. This is what we stand for. And this is what we will continue to stand for. And this is what we will continue to advocate for. However, if you reduce it to insults, we will call you out. Some of us might not insult you back, but you have other people that will give it to you back in equal measure. In equal measure. No, yes, Anjoba Barrow, the application, remember, the defense made an oral application for bail. That was rejected by the courts. The courts have asked that the application for bail be done formally. Formally. Come before the court formally and on notice, where the application for bail will be served on the state. And then the state will have the right of reply. And this is what I'm trying to explain, that of course, so those that are thinking that on Friday, just as you used to think that you're going to go and Bob is going home, I'm saying Sainabou is not going home on Friday. Sainabou is not going home on Friday, because when they come on Friday, the matter will be adjourned. The state will have to reply. When the state replies, they will come back and the matter will be adjourned again for the judge to give his ruling. This is our laws. And yet still, all this while, a person is behind bars. This is what we're advocating for. And now, you see, those feminists that had a very misconstrued and they have a misplaced ideology, that we're advocating and clapping that, oh, rape is a capital offense. It is not bailable. It is not bailable. It is not bailable. You see now what we were advocating for. Well, at least me, Melville. And I am proud today because posterity, history is on my side. And this is why I was calling for. This is what I was calling for. Why must these offenses not be bailable? Why shouldn't they be bailable? Sainabou is being charged for manslaughter. What is manslaughter? Manslaughter is accidental death. Why must it not be bailable? Why must she continue to languish in jail? If indeed it was done by accident, why must she languish in jail until the trial ends because the offense is not bailable? This was my argument. This was my argument. So I want any of you, I want you to share this live video to all feminists. Let them understand. Let them understand. There's a difference between education and knowledge. There's a difference between education and knowledge. This was my advocacy. That a person, just because you have been alleged of an offense, just because they say that, okay, somebody say you raped them, does not mean you should seize the freedom of that individual, because that individual might be innocent. So all these things about, a capital offense is not bailable, it is rubbish. They found themselves in our laws, but they are rubbish. They are rubbish. They are against progressive democratic ideals. It shouldn't be there. They are against progressive democratic ideals. They are against our constitutional dictates. And this is what I have advocated passionately for. So now you see my point, because now you see your Sainabou Mbye. You are advocating, you are saying that Sainabou Mbye is innocent. You are saying that Sainabou Mbye is an accident. And can you imagine, if let us say that it is true that Sainabou Mbye indeed committed an act that was accidental. Now Sainabou is in jail. Sainabou has seen the inside of jail. Sainabou is in remand for something that is accidental. That is, if it was accidental. And this is the same argument. A person that has been accused of rape must not spend 2 years in jail for an offense that he or she has not been found guilty of. This was my advocacy. This was what I advocated for. To say that bail cannot be seen as a form of punishment. Bail cannot be seen as a form of punishment. There are reasons for bail. Go back and look at the historical context of bail. Go back and read and see why, what necessitated bail in the English courts. Go and look at the common law context of bail. Bail cannot and must not be seen as a punishment, because if you do that, you have frustrated the presumption of innocence. This is what I've advocated for. Now you tell me how does Sainabou now, how can Sainabou enjoy the presumption of innocence when she's locked up in mile 2? The presumption of innocence becomes a farce. The presumption of innocence becomes a laughing stock. The presumption of innocence, it amounts to absolute rubbish. It does not exist. This is what I was advocating for. That the presumption of innocence must always be on the side of the accused person. And this is why I have always said that as far as I am concerned, until Bob is declared guilty, he is innocent before the eyes of the law. He resides and dwells in the presumption of innocence. And today, your darling Sainabou Mbye is not enjoying the presumption of innocence, because if she was, she would be sat in her house until she is found guilty by a court of competent jurisdiction. You see the irony of the principles of presumption of innocence vis-a-vis a justice delivery, criminal justice delivery. Today, ordinarily, Bob should have been at home and being tried for an offense that he has not been found guilty for. Ordinarily today, Sainabou should have been at home and being tried for an offense that she has not been found guilty of. That is the basis of the presumption of innocence principle. That is the fundamentals of it. But you advocated passionately against Bob. You talked about how bail was not how rape was not a bailable offense. You got lawyers that were dancing to your tune and playing to your gallery to come and talk about how bail, judges can't get bail, nothing, oh, bail, no, you rape, no bail, no bail. Now you understand how Sainabou is a no bail. You see it. And you will not even understand the gravity of it until one of you feminists is I don't pray for it to happen, but until one of you feminists is alleged of a crime that is not bailable. And that is when you will understand the gravity of what we talk about. And that is when you will understand and appreciate what I talk about. That is when you will understand and be passionate of what I advance. I don't speak based on emotion. I don't speak based on partiality. I don't speak based on what is popular. I speak from the conviction of my heart, my mind, my soul, and my body. I speak based on my understanding and my belief, which I will die for in advancing them. Nothing stops me. No threats. No insults, nothing of that sort will ever intimidate me to a point that I'll go quiet. The only day that I will be silent against injustice, The only day that I will be silent against taking and standing up for the downtrodden will the day I breathe my last and I'm in my grave or my coffin. When you advocate for something, when you fight for justice, do so with an honest, sincere, and credible heart. Whatever you seek, when you go to equity, come with clean hands. Make sure your conscience is clear, your heart and your mind and soul is right. Make sure what you're doing, you know what it is. And you know the very core, the foundations of its existence. Then you can advocate. You cannot sell an agenda that you don't understand. You cannot sell an agenda that you don't know. You cannot advance an ideology that you don't live. You cannot advance an ideology that you are not understanding the very tenets of that ideology. You cannot. And it will fall because there is no foundation. It is not based on anything. It is not based on honesty. It is not based on sincerity. And it is certainly not based on truth. Today, the very thing that you passionately advocate for, go back and look at your recordings. Go back and look at your videos. Go back and look at it. Go back and read your write-ups. Yes, bail is not, rape, the offense of rape is not bailable. It is a capital offense. It is the same damn way that the offense of manslaughter is not bailable. But if you had advocated, and stood and be right in your advancement, in your call for your feminist ideologies, if you had done so with love, with sincerity, with equity, we would have all been together. We would have all been together advocating for what is right. We would have all been together advocating and challenging the status quo. We would have shown the authorities. We would have shown the government. We would have shown the powers that be that real power resides in us. And that there is a social contract between us and them. And that we have extended and giving them the right to lead and the right to rule. But when you sit in your corners and you think you can advance a false agenda, you think you can advance an agenda that is not honest, you feel you can advance an agenda that is not credible, an agenda that is not true, it would only come back to bite you in the face. You never expected that a day will come when they will be taking food for Bob in remand and they will be taking food for Sainabou in remand. You never expected that a day will come that Sainabou will be transported from in a prison vehicle from Mile 2 to the High Court, just as Bob was being transported. You advocated and say, yes, there's an offense where it is not bailable. You advocated for bail to be a punishment. You celebrated when Bob went into jail. You said, some of you said the dog has been caged. You said the animal is no more. But today, can we also say the dog has been caged in the person of Sainabou? Can we? I will not say it because she will never amount to a dog to be. Can we say the animal has been caged? No, we can't. Because I am a person of conscience and I will never refer to any being as dogs. You called him a dog simply because he's an accused person. A person alleged of an offense. A person alleged of a crime. You called him a dog. You called him a rapist. Can we call Sainabou a murderer? Can we call Sainabou a murderer? Can we call Sainabou a killer? Have you seen the balance of probabilities of your ideologies? Have you looked at it and assessed it? Have you? Have you seen how it doesn't make sense? How now you are advocating and saying, oh, Sainabou is going through this, or it was an accident, or it didn't happen. You already, all of a sudden, you are on the other side of the spectrum. It is only God that can do that, to teach you all. If any of you were genuine and sincere feminists, you would call a meeting of the elders. You will sit yourselves down and educate yourselves on things that are true. on things that are real, on things that are honest. You will sit yourself down and accept that you have made mistakes. You will sit yourself down and accept your shortcomings and your shortfalls. Then you would advance a credible agenda, an agenda that is based on honesty, an agenda that is based on sincerity, where we would all call for an equal dispensation of justice for everyone, irrespective of gender, irrespective of race, irrespective of tribe, irrespective of social status. A justice delivery system that is fair to all. A justice delivery system that is equal to all. A justice delivery system where justice would be seen to be done and to be done in a fair and equitable way. This is what we have advocated for. Bail can never be and can never take the place of a punishment. Never. And this is what I have said. And this is what I will continue to say. You cannot have a criminal justice delivery system where an accused person is already found guilty in the courts of law, in the courts of public opinion. You cannot. You cannot. And today you see yourselves. You see yourselves coming out of your hiding holes. You see yourselves howling and calling and checking and now castigating the very damn justice system that you celebrated a few weeks ago, because the recipient of those actions, the recipient of the justice system, was a person you labeled as an animal, was a person you advocated against. And today, you come out of your holes and you want to change the narrative. You come out of your hole and you want to change the narrative. All of a sudden, you want to appear as a saint. You come out of a hole to question the very system that you advanced and propagated and spoke in favor of. It is called hypocrisy. It is called hypocrisy of the tallest order. And I don't know what the Quran says because I don't know the Quran well. But the Bible says if you're neither hot nor cold, God will spit you out of his mouth, because it is better that you're hot or you're cold, so people know who you are and where you stand. But you flip-flop. You're like tennis balls. You're from one end of the table to another. You have no value system. You hold nothing dear to your hearts. It is circumstantial, everything. It is based on what you know, who you know, and how you do it. Today you call for a justice system. When we advocated and said that Bob should not be tried without evidence, you said we were stupid. When we advocated and said that Bob should not be tried without evidence, you called us rape apologists. You said we were inhumane. You asked us whether we did not have daughters. You asked us whether we did not have mothers. You asked us whether we did not have sisters. But today, you come out to decry the very system that you talked about. How hypocritical. It's either hypocrisy or stupidity. I don't know which one. It is either hypocrisy or stupidity. I don't know which one better suits you. Today you come out to talk about evidence. Today you come out to talk about a justice delivery system where an accused person will be brought before a court of law, will be kept in detention, will be kept in remand without a Bill of Indictment, without evidence. You come out without a proper charge before the court. You come out to talk to us about it. You need to shut up. You need to screw it and go back to bed. Yes, I said it. Yes, I said it. You can do a post and insult me for all I care. You can tell me you don't listen to me or you're not hearing me, but I'm sure you are. And I'm sure my message will get to you. You are hypocrites of the tallest order. You come here now today to advocate for a justice system that is fair to all. You never knew you would be on the other end of the law. And that is why I keep saying that we should all endeavor to make sure, to ensure that we have a criminal justice delivery system that is solid. A criminal justice delivery system that recognizes the fundamental human rights of both the accused person and the alleged victim. This is what we are advocating for. For justice, justice must be blind. Justice must not be a respecter of persons. The scales of justice must be equal before anyone who comes before it. You can say what you want about me. You can talk and decry me all you want. But you can never, ever take away the substance that I speak. You don't even have to like me to agree with me. You don't have to. You do not have to agree with me. You don't have to love me to agree with me. You do not have to. But what is undisputed, what cannot be argued, is the fact that our criminal justice delivery system, our judicial system needs a complete overhaul. I don't care who comes out with a press statement to tell me otherwise. I know what is right. I know what I have seen. And I know what I have lived. You advocated for an accused person to be detained and you celebrated it. Today, you are advocating for an accused person to be free and to be allowed to go home. Have you sat down to evaluate yourselves? Have you done an introspection of yourselves? Have you assessed your integrity? Have you assessed what you stand for? And have you assessed your value system? I will never advocate for Sainabou to languish in jail. I will never advocate it. Because if I do, it will make me inhumane and it will bring me to the same level as her and her supporters. I will never do it. I will passionately advocate that she has a fair justice delivery. That justice will be dispensed in a very fair and equitable way in her case. I will advocate that the law is true and honest on her side. And trust me, I will advocate in the loudest and strongest of manner that if the state cannot justify the charges that has been brought against her, that she should be let loose, set free, and allowed to go and do her business. I will advocate for that because this is what I believe in. Because my advocacy does not know and is no respecter of persons. It is no respecter of persons. I don't advocate based on personality. I don't sit here and talk because it's Bob. I don't sit here and talk because it's Sainabou. I sit here and talk against a system that I know. A system that I have lived and experienced. That if it is not changed, if it does not change, if it is not revamped, then every man, every boy child suffers an existential threat in that country. This is what I say, and this is what I preach, and this is what I advocate for. You might say, I don't live in the Gambia, it does not bother me. But you forget that you have a boy child that will travel to the Gambia, where a ridiculous, insane, evil, bad person can come and allege them of an offense that they haven't committed. Where they will be bundled up and sent to mile 2 whilst investigations are ongoing and the evidences to substantiate the charges are being sought and looked after. So, it's not about me, it's not about you, it's not about so-called feminists. Absolutely, Prof. Absolutely. I have said it, that the courts have indeed violated the rules of court. And not only have they violated the rules of court, they have violated the Courts Act. Because the rules of court are just rules. They are just rules. But the statute law, the Courts Act is statute. It's statute and it overrides every rule. And it is very clear that when there is a criminal matter before a court of law, when there's a criminal matter in the High Court, you do not adjourn the matter to go on vacation. No, you don't. A criminal matter, you don't adjourn to go. They don't have the law, and this is what brought about so many debates. It's very clear. It is not only law, it is logic. It is logic. Because you have a person in remand, a person in detention, a person in jail, and you go on a holiday. It is against moral conscience. It is against good conscience. It is against empathy. It is against humanity. It is. And this is the law. The law is not blind. The law is not static. And that is why to every law there is a mischief. There is a purpose. There is a purpose. To every law. Where a law is legislated, there's a rationale behind that law. There's a reason that that law came into existence. There's a reason that the law came into existence. Because when the law looks at human enterprise, when the law looks at empathy, and you tell me how will you go on a vacation when you leave an accused person that has not been found guilty by a court of law, that has not been convicted, you leave them behind bars, you restrain their movement, you restrict the fundamental human rights to move, and you go on a holiday. It doesn't make sense. You see, the law has to make sense. The law has to be accompanied with logic. And this is what we're saying. Anyways, the matter has been adjourned. I have said what I gotta say. And I was going to speak on the Gam Petroleum judgment by Justice Hadi Roche. I can never pronounce the name properly. Hadi Ross or Rouge? Rouge, but you know who I'm referring to. And because there's a lot of comments, there's a lot of, back and forth that, oh, why were there matter done in 3 months and Bob is there for 2 years and things like that. But I do not have the judgment. I do not have the full ruling because the ruling I got is based on the count. So I have the ruling of count 1, there's a ruling of count 2. I think there were 8 counts. So I want to wait until I have all the rulings of all the counts correlated. Then I can look at it and then I can bring it to you so that I can break it down for you, and then we can delve into a legal analysis of it, and then we will do that. So I will adjourn. I say adjourn, sir. So I will not take that now. I will not discuss that now. I will do that later when I have the entire ruling. So what time is it now? I have no idea. So that's it for today. I'm just going to, so anyways, I was just going to say lastly, please, I have a page called Melville Roberts in Roberts Esquire. What I'm trying to do is, this is my personal Facebook page, and I'm trying to get that page running where I will talk about discussion. So because this page, I have people that I blocked that me and them were not, I blocked them. I don't want to see what they're at. But that page, I've decided I'm not blocking anybody on that page. They can do whatever they want, so they have a right to be there. They can exercise their fundamental human rights of association and or watching or whatever it amounts to. So really, you can follow the page. The page is called Melville Robertson Roberts Esquire. You have to be very careful because my Facebook personal page is Melville Robertson Roberts. However, the page is Melville Robertson Roberts Esquire. I'll share it so you can follow it because that's where I'll be doing all the legal analysis, all the legal discussions. And somebody asked the question whether the audio can be used in evidence. You see, let me say something. You see, when that audio was played, if you go back and watch the video, the live feed where that audio was played, I did say, and I said to Paos, I said, this person who is explaining the narration of how this child died is incriminating herself. I said to Paos, and I said to Paos, you and you guys on this platform were putting this girl into deep shit, into hot soup. I said it. Yes, absolutely, Prof. They failed, and that is what the law, that is what the courts held, that they failed. But again, it takes you back to a criminal justice system where accused persons are horridly brought before a court without even having prima facie evidence established against them. So this is what we're saying. So it's I don't know how to share it there because I'm using my phone, but it's called the Melville Robertson Roberts Esquire page. I don't know how to share it here. And I couldn't reach Charlotte because she's the one that manages the page, but I couldn't reach her. So I'm going to just dedicate 5 minutes. If you have any questions that you want me to answer with regards to the issues that we have discussed, just 5 minutes, really 5 minutes. If you have any questions, if you can just, can someone who was extradited be granted bail? Yes, absolutely. Extradition is an extraterritorial what's your trying to say? It's an extraterritorial act. So when you extradite a person, what it shows only is that you're removing that person from one jurisdiction to another to face charges. So once they get into the jurisdiction where the charges are being the person is being tried, then ordinarily the domestic law of that country just kicks in. So it doesn't matter if the person is extradited or not. It doesn't matter. The extradition is just for the purpose of getting the person to come and answer charges in the home state where the charges have been brought against them. So that is the reason for, that is the purpose of extradition. Yeah. And so, for example, Sainabou was extradited because she was, apparently they said she was refusing to come to answer to the charges. Yes, bail is always at the discretion of the courts. And that is my opinion that I've always advocated, that bail is always at the discretion of the court. Safia asked the question, I can't find it anymore. I can't find it, Safia. You know, my eyes are not good. Safia, I can't find the question. Melville, about the audios you get at hand towards the case, can't you send it to LS Camara as evidence in court? Oh, absolutely. They have already been sent to LS, and that is the reason why I have not played them. So they have been sent. So I have. You see, I am not an irrational person. So me, I don't respond to certain things. Me, people do not understand me. I do not always respond to everything, Safia. And there are things I respond to. There are things I don't. I know what I know, and it is not because a person says something that would make me respond. You can insult my mother. I can choose not to respond. I could choose not to do anything. So I did not respond to all the rubbish I saw that was being written. Oh, but how are you going to keep the audios and not helping and not stuff that? No. That was not why they were saying that. They were saying that because they were so nosy and busybody, and they wanted, being busybodies, they wanted to listen to the audio. But I know that these audios would be used in court, so definitely I wasn't gonna play them. Is there any other question that I missed? I am scrolling to see if there's any question. Yes, let me just explain. I don't know. I've explained this before. I don't know if I should do it or I have time. Maybe I should leave it on. I was just going to explain the reason for bail. I was going to explain because I think a lot of Gambians should understand. And lawyers, judges don't understand. There are some that do not understand. They think bail is a form of punishment. You would see state councils that would go to court and just say, oh, no, we reject bail. What's the reason for the bail? They just reject it because they feel that that person has to be punished. No, that's not the reason. I'll run it down quick. I'll talk about it some other time. I've mentioned it before, but let me just do quickly and then I'll end. There are 4 principles that have been laid down for bail. And this is the reason for bail, where bail can be refused. 4. 1 is where the person has committed an offense, and it is likely that if that person is let loose, that person would likely commit the offense again. The offense, it will a reoccurrence of the offense. So I always give an example. If I slap Anasar, and then I am a person who I like to slap people, they will keep me, they will deny me bail because they know if I go out, I will most likely slap another person. And by the time you know it, I have 10 cases of slapping in court. So it's 1 where a person would likely, the offense would reoccur. Okay, that's the first one. The second reason for bail is where the life of that individual is at stake. The safety and life of that person is really at stake. So for example, now Sainabou Mbye, I can give you an example of Sainabou Mbye. The way I see the public reaction and perception towards Sainabou, if you release Sainabou on bail, you might be jeopardizing her life and her safety. So in those instances, you would deny bail because you're not keeping the person in custody because you want to punish them. You're keeping them in custody in an environment where they're protected during the course of the trial. So that's the second instance. The third instance is where the person is what you call flight risk. Flight risk. So that is, for example, where the person would ordinarily leave the country, leave the jurisdiction. Like they call it flight risk. So where, of course, you know, when a person has a charge against them, you want them to appear in court. But where you know this person is going to vanish, is going to disappear, is going to come out of the you know, so I was just trying to read that. So where you know that the person will be a flight risk, yes, then you would deny bail because you're not punishing the person, but you know the person will disappear or the person will go away and then they will not appear before you in court, and then it means that the matter is frustrated because you cannot continue the matter where the person is not there. That kind of thing. So that's the third one. And the fourth one is where the person will tamper with the investigations or the witnesses. So if you know, if you release Melville, Melville will go and meet the witness in one corner, bribe them not to come to court, or will tell them, oh, this is what you should say, don't say this, that kind of stuff. Or they will go meet the police or whoever is conducting investigation, try to change things. That's it. So these are the instances where you refuse bail. You do not refuse bail because you have the power to refuse bail. That is rubbish, man. So this is what these people don't know. Go and read about bail. Go and read about how bail evolved. Go and read. A person that has not been convicted of a crime, you just hold a person because you feel you have the right to, because you want to punish them. Nene Frida Gomez, no, I cannot marry you. Me, I cannot marry somebody who is fighting against the state, because when I marry you, instead of you cooking for me, I'll find you standing on a piece of land and showing people that you are, this is my bricks and this is my sand and this is my block. No. If I marry you, I want to meet you at home, cooking for me. But when I marry you, you'll be standing holding a card. Say, this is my land, this is my bricks. You'll be telling people you're waiting to, you know, if President Barros comes here and steps foot here, wallahi, I'll take him to court for trespass. Me, I marry you. Lie. Nene go away, leave me, Sha. Anyways, guys, it was fun being with you all. And I thank you guys so much for everything. As usual, it's always a teachable and learning moment. I learn from you guys all the time. I appreciate. I'm just trying to share my own little knowledge of what I know in my own Council Melville. Shouldn't the defense team have filed a certificate of urgency? Yes, they have filed a certificate of urgency, Prof. But don't forget that there are two routes to filing a certificate of urgency. The first route to filing a certificate of urgency is actually bringing that application before the presiding judge who is actually hearing the matter. So that is, for example, Justice S.M. Jallow. So the defense should have brought that application to him to say that, okay, you're going on a vacation and we're filed a certificate of urgency. And don't remember, filing a certificate of urgency is not just filing it. You have to fulfill, you have to show the court the reason why the matter is urgent. And of course, where you have the accused person behind bars, that is prima facie, grounds for urgency on this matter. So, but then the presiding judge had intimated that he wouldn't accept it. He said he wouldn't accept it. And because he said he wouldn't accept it, if LS had made or had brought the application before him, it would have been a futile exercise because he had already intimated that he was not going to entertain the application for the certificate of urgency. So now it means that LS has another route, which is to make the application before the Chief Justice. And if it is granted, then the Chief Justice will then assign the matter to the vacation judge. Yeah, so that is what it is. So the first route, which is to bring the certificate of urgency before the judge, the presiding judge, where the matter that he sees of the matter of the substantive matter, was not done because of that reason, because he had already intimated that he was not going to accept it. So I think the second route now is what is being explored, and that is bringing the application before the Chief Justice, and if it is accepted and or approved, then it would be the matter would be heard before the vacation judge. So I do not have information on what has been done yet, because I haven't spoken to LS or anyone today and or yesterday. So I'll try to find out, and then I'll keep the public updated on that. But it will be great, and hopefully and rightfully so, to have the matter the matter be heard by the vacation judge, because not only do I want the matter to be brought before the vacation judge, just to make sure that the trial is ongoing, but the other fact is that if the matter is brought before the vacation judge, then you have another individual, another judicial officer who has a different perspective to the matter. And remember, the vacation judge has all rights. All rights. In fact, the vacation judge can set aside the order of the court, of the DNA order of the court that the previous judge had granted, because the vacation judge has every single right as the substantive judge that the matter is before. They have all the rights. So an application can be made subsequently to that judge to ensure to get some of the orders either varied or set aside, and if that particular judge has the right to do so. So I hope I explained that, Prof. And Loretta asked the question. Oh my God, I want to drink water. In lieu of not granting bail, will you ever advocate for ankle monitoring bracelets for accused persons and releasing? Oh, absolutely. That is what is being done in the world now. I mean, who wants to put somebody on bail when you don't even know if they've committed a crime, and you put them there, state resources being used, the prisons are cramped, and so many things. You don't want to do that. Of course, the ankle bracelet, because the ankle bracelet will, but again the ankle bracelet, really, it would just satisfy the bit about flight risk. That's the other part, but it doesn't address the other issues, the reoccurrence of the offense, the tampering with investigations or witnesses, and of course the threat to the accused person's person and or life. So the ankle bracelet really would just suffice for the bit about the flight risk. That's all it would address, really. And that is why it is one, even here in England or in America. That's the purpose, the flight risk issue of not having the person go within a particular. And for example, in England or in America, where an offense an offense has been, somebody commits an offense and they don't even want you. Sometimes the bail condition, they don't want you to go to a particular location. So what the ankle bracelet does is that it actually monitors the movement of the accused person, so that areas where you are prohibited from going, you don't go. Because if you do, then of course it sends it back to the headquarters. They know exactly where you are, and most likely that would be a condition of your bail being revoked, because you breach the conditions of bail by going to an area that you're not supposed to go. So that is one of the reasons for it. My friend Ismail would say halas. Anyways, so that's it, guys. I wish you all the best. I've tried to answer the questions and I've tried to explain things as I know it and understand it. I may be absolutely wrong, but that's it. So goodbye. I wish you guys all the best. I don't know when I'm coming back on events. I don't know when we're having another program. Oh, when I get the when I get the thingy, the judgment of the, when I get the judgment from the of the what's it called, the GAM Petroleum case, then I will do that. Yeah. So you guys take care and have a good night. Love you all. Bye bye.